Hello, I'm Dan Beaton, a member of NEPC's Defined Contribution Consulting team. Thank you for joining us for a webinar on the recently passed Secure Act of 2022, or otherwise known as Secure 2.0. This is a huge piece of retirement legislation that has many provisions to it, and it's about 92 provisions in total, and it's largely viewed as enhancements to our current defined contribution system. So we thought it'd be best to help plan sponsors with a two-part fireside chat type discussion. For part one that you're tuned into right now, we're going to take more of an immediate future focus and talk about some of the provisions that are in place now or coming soon in 2024, in less than 10 months from here in February. Part two will be a little bit more of a wide-ranging discussion on some of the longer-term impacts of Secure 2.0, some provisions that are coming down the line. We are not going to mention some of the provisions that are tied to new plans and the currently uncovered participants. We thought today's audience is going to be mostly established plans, so we're no means ignoring those, but for today's discussion we will to an extent, so we can focus on the things that are going to be most impactful to our clients. So today I'm joined by three panelists, as you can see on the screen. We have two on the legal side, one from NEPC's consulting team with me. On the legal side, we have Marla Kreindler and Greg Needles from Morgan Lewis. They're both partners at Morgan Lewis and members of their employee benefits practice group. That's one of the leading employee benefits practice groups in the nation. So we're pleased to have them join us again, or in Marla's case, join us again, Greg, for the first time to talk to our clients about legal and regulatory items. On the consulting side, I have Bill Ryan, a familiar face to some of you. Bill is a partner at NEPC and the head of our Defined Contribution Solutions group. So Bill and I will give the consulting perspective on some of these items and talk about what our clients have been interested in here in the first 2 months or so of Secure 2.0. So with that, let's dive right into our first discussion. I think what makes the most sense is to have Greg and Marla outline some of the items that are going to be impacted here already in 2023 or early in 2024, and the ones that are down the road in 2024, I'm sure will find their way into meeting agendas here later in the year. So let me turn it over to Greg, and he can talk about some of the things that are most impactful immediately.
Thanks, Dan. We've been out talking to clients the last month or so as this Secure 2.0 is rolled out, and there seem to be three provisions that they're interested in. One being the change in the required beginning date. That's immediate because it went into effect right on the date of enactment, and it raised the required beginning date from 72 to 73. And they've been, I shouldn't say struggling, they're just making themselves aware of the fact that their participants that would have attained 72 this year, turned 72 this year, who no longer have to start taking distributions from the plan. So that is one that's front and center for them. The second is the Rothification, if you will, of catch-ups, and in particular, the $145,000 limit, if you will, or floor. So if somebody makes $145,000 or more, if they elect to make a catch-up, it's got to be into the contribution that's got to go into a Roth. You know, this is under the heading of revenue provisions under the Act. So this is something that was intended to fund the rest of the Act, among other provisions. And so that's now in there. And so they're wondering how to plan for that, because they have to determine who makes $145,000 and who we're going to have to make catch-up contributions on for. And in particular, I mean, when determining the $145,000 amount, they can look back to the prior years, so that's good. But also, the Act requires that if you haven't offered catch-ups, you have to offer catch-ups to everybody in the form of a Roth. So that is causing some concern, particularly for clients that don't have Roth in their plans right now. And lastly, it's the ability for a participant to elect to have employer matching contributions and non-discretionary contributions contributed in the form of a Roth or converted to a Roth. And in order to do that, the Act requires that the employer contributions going into the plan must be fully vested. And then the participant can elect to make that or have that contribution converted to Roth. The concern there, of course, is there's not a lot of employers, particularly those with vesting in their plan, that will want to change their plans to make it implement full vesting, because they'll lose all the forfeitures that they're counting on to balance the cost of the plan. So those are the three that I'm grappling with, or our clients are grappling with right now.
Great, Marla. How about you? Do you have some items that you're talking to clients about specifically?
Yeah, one of the ones that I found really interesting, including, from a policy perspective, are the pension-linked emergency savings accounts that are going to be effective and available to plans, not on a mandatory basis, but on a voluntary basis, beginning January 1, 2024, so next year. So that's pretty soon, as you said. And what they're doing, it's interesting, the name is pension-linked emergency savings account. And sometimes when you think pension, you're like, oh, you mean the pension plan, not DC. But these are meant to go into effect for DC plans in the industry. We're calling them PISAs, pension emergency savings accounts. And maybe that's because it's easier to say here. But basically, it allows DC plans to include pension-linked emergency savings that would be offered to non-highly compensated employees on a Roth basis. So those employees who meet the eligibility requirements, and allow them to contribute up to $2,500 that they could then take out and to help them save on an emergency basis. And so what we saw, over the past couple of years, was we just saw so many participants that did not have enough emergency savings outside of their retirement plans. And so what that meant, and even now we're just seeing such a high level of withdrawals from plans, and hardship withdrawals, maybe higher than that I've seen reported than we've had in the past. And so the idea here from a policy perspective is to encourage participants to contribute emergency savings. And then hopefully then that will keep them from having to access what we think of as otherwise their retirement savings accounts within the DC plans for emergency purposes. And so the idea of these emergency savings accounts was to try to increase participation and then reduce leakage, because folks would have money available. But unfortunately, the way that the law was written, it does come with some complications and some administrative requirements that people are thinking about, and that are causing a lot of discussion. So there's no minimum account balances or contribution requirements, and that withdrawals can occur without an excise tax, and the first 4 withdrawals in a plan year may not be subject to any fees or charges. And so I think when you sort of hear that, you start thinking about how loan programs used to be administered, where folks were sort of thinking of them as like their savings account, and is that really what plan sponsors want to see with their DC plans? So the questions on administration, I think, are coming to bear. But then also, the pension-linked emergency savings accounts are also required to be invested in short-term investments, specifically cash, interest-bearing deposit accounts, or certain investment products, like, for example, that stable value may apply to. So it's an interesting provision, but there's certainly, some things to think about there, from an administrative perspective, I think, before plans are going to be rushing to adopt it. Another provision that we've received a lot of interest in and questions on is the provision that allows for de minimis incentives to allow for improved retirement plan participation. And so previously, you weren't allowed to give employees incentives or other benefits that were contingent on them participating in a DC plan, other than the matching contribution, of course, which we're all familiar with. But what Secure has done is it's opened the door to allow for de minimis incentives, as long as they're not paid from plan assets, to get people to participate. So you think about like that at employee meetings, so maybe water bottles or modest gift cards or whatnot that we then can can have these incentives used to get people's attention and hopefully increase participation.
Great outline there, Marla. So maybe turn it back to Greg for a minute here. Greg, I think it's probably important to recognize that not everybody on the call may be familiar with the pain points of changing regulations, and they may be a decision maker, but might not be getting their hands dirty on all the administrative issues that creates. So if you could maybe spend some time on what that means when you do change something, and with a lot of these being optional, what the decision could be the easy part. The hard part could be actually implementing that within the plan.
Yeah, let me take the 3 provisions I mentioned as examples. So for the required beginning date, that's not optional, that's required. And so talking to clients about that, how do we inform our participants about this change? They've certainly heard about it in the news. They're attuned to that, but there's others that haven't. There's no requirement that they inform the participants. And so it's, they're talking about, do we need to do some kind of communications campaign? They're hoping vendors will take that up. And that's been the case in the past. And I think that's ultimately what's going to happen again. But, they're going to have to make sure that somebody's getting the word out to their participants. And also they need to make sure that the vendors are implementing the required beginning date now. I don't think that's a real concern because they knew this was coming, and so they programmed it. But it's you still have that due diligence and oversight to make sure and confirm that they're doing that. Now, fast forward to the Rothification and the implementation of the required Roth contributions, which goes into effect next year. So you talk to clients and initially say, well, that's a year away, no problem. But then when they start to think about how they're going to go about implementing that, like I said, they're going to have to determine, look back to see who's made over 145,000. Then they got to go to their payroll folks, and their payroll folks have got to figure out, okay, if I've got a highly compensated employee who's elected to make their Roth contributions in a pre-tax, not after tax, how do I program the system to flip that switch? And that's something that I think is going to be not problematic, but difficult for the payroll department to work through, because it means that they're going to have to take pre-tax election and convert it to a Roth and make sure that that's done consistently. And that involves putting in the safeguards to make sure that happens. And lastly, the provision that allows employees to elect to go from pre-tax employer contribution to matches to elect that to as Roths. That's an optional provision that goes in effect immediately. But when you think about that, it's how do you work that through, again, your payroll system? Because typically when a contribution is made into a retirement plan and it's pre-tax, it doesn't hit the payroll. I mean, it's outside of payroll. But now that you're converting it to a Roth, you're going to have to make it go through, because it's going to be subject to W-2 withholding and FICA and Medicare tax, etc. And yet you don't have any cash. There's no cash that's going through the payroll system at the same time. And that's it. That's going to cause, again, sleepless nights on your payroll director's part to figure out how to manage that. So there are challenges of the act that I don't think Congress, I'm not sure Congress really cares about that. It's just, something for employers to consider.
So Marla, can you just talk about some of the fiduciary guidelines around the pension-linked emergency savings accounts? Anything interesting you think is worth pointing out for those?
Yeah, I mentioned previously that these investments are limited to certain types of short-term investments, such as cash and interest-bearing deposit accounts. And everybody has looked at it and said, yeah, stable value accounts too, because there's language in here that says that you can invest it in products that are designed to maintain over the life of the investment the dollar value equal to the amount invested in the product, and preserve principal and provide a reasonable rate of return. So this sounds like stable value to me. But on the other hand, there's a second requirement to this type of product, which says that it needs to be offered by a state or federally regulated financial institution. And so if you think of, like if a plan sponsor has a stable value product that's an insurance contract, okay, I think it meets that requirement. Or if you invest in a CIT, a stable value pooled fund, that's offered by a trustee that's going to be state or federally regulated, I suppose. But what if a plan sponsor has an institutional stable value fund? And is that offered by a state or federally regulated financial institution? I'm not so sure. And this may require, some type of follow-up or technical correction, because I don't think the intent was to say that if a large plan sponsor has their own stable value fund, that, hey, that isn't going to meet this. But I do look at this language and scratch my head about it, and want to hear more about, what's needed here, or what qualifies. So let's keep an eye on that.
Yeah, it's a great point, Marla. Thank you. So let's bring Bill into the discussion now. Bill, I know we're going to have a deeper discussion in part 2 on plan design, but can you talk about, what might start to receive more attention from plan sponsors? What type of plan provisions will start to receive more attention from plan sponsors in the near future as we discuss these other items?
Thank you, Dan. I think what Greg and Marla just said is spot on. I as recently as this morning, I was in a committee meeting where the Rothification came up, the payroll challenges came up, and the other thing was the debate on emergency withdrawals and pieces. So I think there's good intention that's happening. I think the focus for the next 12 months, to Greg's point, is going to be on the application or the implementation of Roth. Because I had a client, yesterday's client meeting actually went through, they were trying to think about their own match structure, which flows through on a certain dollar amount on a pre-tax. And the information went to their record keeper, it came back, and if they didn't do it in a certain sequence, the employee wouldn't get the full match. And the catch up was a calculation figure out. So when Greg just went through it, same thing's true on which dollar becomes pre-tax and Roth based on the limits, because you may be set up on a percentage or a dollar amount basis. And if the record keeper doesn't have the salary as the denominator, there's going to be an accounting item that we need to work through from how cash flow happens. And then where Marla was just ending, and I think we're going to go into the emergency provisions, stable value is going to become front of mind for a lot of people, not just because of the interest rate environment we're in, but because of it being the mechanism for the pension-linked accounts, as well as the application it could have in retirement income. So I think those are going to be the things that we spend a lot of time with our clients going forward, dovetail with the provisions and some of the external tailwinds that would support both of them.
Great, thanks, Bill. So maybe as we wait for Marla to come back on, we'll talk about some of the increased penalty-free withdrawals provisions that are in Secure 2.0, and maybe have Greg start out with some of those items that he'd like to highlight and have talked to clients about.
Yeah, no, there are a couple of provisions that are of interest right now to clients among the penalty-free withdrawals. One is for victims of domestic abuse. That provision was added by Secure 2.0. It allows participants who've incurred domestic abuse to withdraw up to $10,000, or if their account balance is less than half the account balance, to address the issues that they've endured. And it also allows them to pay it back over a 3-year period following the year in which they make the withdrawal, and not subject to the 10% excise tax. So that's all good. And I mean, it's provides a participant access to their money in time of need. the question is with these, and this is what the clients are struggling with right now, with these withdrawal opportunities that are not retirement related, whether they really want to take that on and the additional administration that they require. It's a matter of focus. Our focus is really on, this is a retirement plan driving, retirement savings, so our participants have, and our employees have adequate retirement when they leave here. And now all of a sudden they're expanding to it's a source of cash to help people out in a time of need. I think with the domestic abuse provision, it's going to be very tough for an employer not to put that into their plan, given the origin of that particular withdrawal and the nature of that particular withdrawal. So I think that's a challenge. And likewise, it's going to be a challenge for employers who have a participant who's terminally ill, not to gain access to their account balance and make a withdrawal that's, again, not subject to 10% excise tax. And even then, that particular provision provides for a payback in case the individual actually recovers and is no longer terminally ill. And I think the employers are, you're not going to deny somebody in that position the opportunity to gain access to their account, but it does add additional administrative complexity that they didn't otherwise have in what are already very complicated plans.
Sure, and maybe Marla, if you could talk about the emergency withdrawal provision or for personal expenses, which is of course different than the emergency savings.
Yeah, thank you. Yeah, so Secure, in addition to the pension-linked emergency savings accounts, basically for distributions made on or after January 1 of next year, that participants will be allowed to make distributions from their 401k plans and other individual account plans of up to $1,000 to cover unforeseeable or immediate financial needs relating to necessary personal or family emergency expenses, with no 10% excise tax applicable to this withdrawal. And so again, it's administration is going to be one of the questions about this provision, but in an effort to ease administration, Secure 2.0, it permits participants to self-certify their eligibility for this type of distribution. So we won't hopefully have the plan fiduciaries worried about, does the participant really have this immediate financial need or not? And so that, I think, is really helpful. There is room for Treasury to issue regulations on when self-certification may not be relied upon. I hope that they exercise, should I say, grace and not giving us anything that would cause more concern from fiduciaries that are interested in adopting this provision. And like what we've seen with other types of distribution provisions that have been allowed over the past couple of years, that there is an opportunity for the participant to pay the amount distributed. And then there are some rules about when you can take another distribution of this nature that you've already taken, basically that requires you the participant to repay it or to make elective deferrals to the plan equal to the amount of the previous distribution if it hasn't been repaid. So I think this will be interesting even for those employers that aren't thinking about the pension-linked emergency savings account, that this withdrawal provision might help participants that are thinking about, should I contribute money to the plan or should I hold on to that money because I may need it for an emergency savings type reason?
Yeah, it seems like it would be a great feature for those participants. So Bill, maybe, looking into the future here as these provisions come online in 2024, if it's an either or discussion, do you think there's some kind of decision tree for a plan if they're going to add either the emergency savings provision or the emergency withdrawal provision? Is there one that might be better for certain plans?
Yeah, I think it's going to be trade-offs, to your point, and I appreciate you setting it up as an either or to get me off the consultant. It depends. answer. But the reality is, I think plan sponsors are going to have to look at their usage, what their current loan provision utilization is, who they're trying to solve for, also what their financial wellness programs are. I think to really affect these changes for a participant who is mindful enough to use the pension linked accounts, they're going to have to delegate a dollar that's going to go into this account and know how much they're saving for. So it's going to take a level of planning for them. And I think that's going to open up further support or need for wellness programs to make sure the participants are using these correctly. Where the emergency withdrawal is, you'll have the mechanism you can take money out if you didn't plan for it. So it may be that you need both, but it's going to come down to your population type, what your benefit structures are, and how you communicate to your participants, because you don't want to have this set up that money gets trapped into stable value and versus being invested in, say, your target date funds, because you're intending for an emergency that never happened. So I think there's going to be a lot of debate on who does this fit, and there could be subsets even in a population that one's better than another. But to tie off your earlier point, the simplest one would be the emergency withdrawal, but there's other upsides with the pension linked accounts to be considered.
Great, thanks, Bill. And Greg, we didn't talk about it, but the CARES Act, obviously through COVID, was passed, and now with some new withdrawal provisions and rules around that, are there any learnings that we can carry over from the CARES Act that can help in analyzing these new options?
Yeah, I mean, from an administration perspective, I think the challenge that the CARES Act has brought to the fore is the 3-year payback. That's what we're hearing from clients, is that for those clients that took advantage of offering the emergency withdrawal during COVID, and now they're getting participants who now want to pay back what they received. They're trying to figure out, okay, how do we do this? How do we manage that? Obviously, it's a record keeper issue as well, and hopefully the record keepers are able to do that. But from the client's perspective, it's trying to figure out how to implement something that they haven't had to do before. The upside to that is those clients that did adopt those provisions will have that experience they can draw from if they decide to implement emergency withdrawals or the domestic abuse withdrawals. So that's a good thing. But there is a bit of ramp up and knowledge that has to be gained before they feel comfortable doing so.
So Marla, maybe you can put a bow on this topic. Any other considerations that clients should consider when thinking about these?
Yeah. So whenever you're thinking about amending the plan, then I think you need to exactly be doing that, thinking about what plan amendments are going to be required, what changes to the services agreements might be required, and for plan sponsors that have institutional stable value funds, so meaning they're not in a pooled fund or an insurance contract, but instead have their own stable value fund, you're going to have to think about working with your stable value managers so that all these different types of plan amendments, not just these, but other secure 2.0 plan amendments, are going to be things that are going to be consented to by the wrap providers in the stable value fund, so that you don't have any hiccups with the stable value fund, because those contracts generally require notice of plan amendments. So let's all keep that in mind as we work through Secure 2.0.
Good reminder there. Yeah, thank you. So we're getting to the end of part one, and maybe I'll turn to Greg and Marla one more time just to hit on a quick lightning round of some of the other provisions. I know we're not going to hit everyone, but maybe talk about some of the other provisions you think clients should know about that are coming up in Secure 2.0.
Sure. The Roth not subject to RMD requirements. This is something that's a boon for participants, but also for those employers that want to continue to maintain the assets of retirees and former participants in the plan to keep their asset levels high. So right now, with IRAs, if you have a Roth IRA, the required minimum, you don't have to make required minimum distributions. You're exempt from that, which is great. And what Secure 2.0 does, and this is effective 2024, if you have a Roth account within your 401k or 403b plan, you're not going to have to make required minimum distributions out of that plan. So you can maintain your balance within the plan. And I said, that's, that's a very, that's a great provision for participants and for those employers, and we have some that want to keep the retirees' money in their plan. This is a helpful provision. So that's the first one. The second is the employee certification for hardship distributions when it comes to immediate financial need. That's really helpful from an administration perspective because they already can self-certify as far as amount is concerned, but you still had to ask for proof as far as the immediate financial need is concerned. And now that's off the table. Unless you have actual knowledge that somebody doesn't have an immediate financial need. And what that means is going to have to be fleshed out in IRS regs. You can rely on the employee's self-certification. And that's something that's been employers and record keepers have been grappling with for 20 years, and it's finally off the table. So good for Congress for doing that.
Yeah, we worked with Treasury on regs on that a while ago. And it's just so nice to see a better fix for that. Yeah.
Yeah, it really is. And then lastly is the increased dollar limit for small benefits in plans, so small cash account balances. That's gone up from 5,000 to 7,000. It's only taken 27 years to get that increased. But that's great from a plan administration perspective because it just gives you the opportunity to clear out those dormant accounts. And we're seeing clients go through that right now where they're, clearing out the $5,000 accounts. And now they can up that to $7,000, and it just gets people off the books that are just no longer have the plan, no longer participating in the plan, and really don't have enough juice in their account to maintain the plan, an account in the plan. So another good thing for Congress to have done. The only thing they didn't do there was they didn't add a COLA to keep that amount going up. So I guess we'll wait another 26 years to get it up to 9.
Okay, Marla, how about you? Anything you think worth highlighting?
Yeah, there are a couple of things, one from a policy perspective that I find interesting, and this is something that we've seen DOL issue guidance on previously, but just the idea of auto portability. So what does that mean? That means that when amounts are cashed out, as Greg was just talking about, that they could be transferred to a default IRA to be automatically transferred to a participant's new employer's plan when they leave. And the idea of this is to keep the leakage from all the cash outs, from just leaking out and not going back into retirement plans, and to provide for this auto portability. And so this could be a really interesting and significant way to address leakage, particularly for participants that might change jobs often, have small account balances, never be able to get their account balances higher. And so the idea here is to allow for this aggregation, which, for plans could also be good, because then you're putting smaller account balances together, right? So that it can help from a record keeping and administrative perspective. So we see this as all interesting and good. We're waiting for DOL to issue guidance. They've been directed to issue guidance by the end of this year, basically 1 year after enactment, so 12/29. So we'll be looking forward to that and see if this is, from a policy perspective, can really help evolve how we think about, plan participants terminating employment and what happens to their account balances, instead of buying going on vacation or using it for something around the house, can we keep it in the system, which would be good. There were a few things that were adopted as a part of Secure 2.0, that the providers must acknowledge fiduciary status, compensation must be disclosed, but I think these types of requirements seem workable to me, and so hopefully we're moving this provision in a good step. And then if I can end on a good news front, which is that we also saw Secure 2.0 require DOL to establish a lost and found database. So meaning when participants go missing, we've just seen this be something that's become just quite a problem, including for plan sponsors and audit, where we've seen pretty, hard positions taken on, how much have they searched for? Could they find missing participants? Were they making RMDs when they should have, for these missing participants? And instead, what this does is not exactly immediately, but within 2 years of enactment, DOL is supposed to create this online searchable database that allows participants and beneficiaries to find their plan administrator and contact information in any plan in which they have a benefit. And so we hope that this will allow people to be connected with their account balances that have been lost, and be a boost is also for plan sponsors in solving the missing participant issue that folks have been working so hard on already.
Great. Well, thanks, Marla. And so with that, we'll conclude part 1. I want to thank everybody for joining part 1, and be sure to tune into part 2, where we talk a little bit more into the future on what's coming and what that could mean for the industry. So we'll get Greg, Bill, and Marla to break out their crystal balls in part 2. So thanks again for joining, and we'll see you in part 2.